Navigate the journey to becoming a great lawyer with expert guidance on topics that range from trial skills to corner office management. Here you will learn how to tap into your potential for legal greatness. I'm Andrew Smiley, and this is The Mentor, ESQ.
And hey, everybody, very excited to have you here with me to kick off the new year. I know we've all got a lot of stuff going on that we pushed off from the holidays. And so things are busy, and I appreciate you carving out a little bit of time today. And let me go over a little bit of what this new series is going to be. It's the Win Before You Walk In. This is going to be, I believe, a 7-part series we're doing. And the idea is that the overwhelming majority of lawyers in the state will never try a case. Very few cases go to trial. I know that I lecture a lot on trial skills and I teach a lot about how to try a case, but in order to expand that, the reality is that most cases are resolved before trial. So what I'd like to do through this series is really work with you all so we can focus in on how to get these cases resolved before trial, all right? And that means before you go to pick a jury. And most cases will resolve one way or another before it gets that far. So I think it's important that we go through these phases. And from the minute that you sign up a case or the minute that you're assigned to file on a case, there's always going to be opportunities to get that case resolved. And throughout this series, we're going to identify those opportunities and know when to strike. One of the polls I've asked Michelle to do for us today, I'm curious, if this was live, I'd ask for a show of hands of how many of you do plaintiff's work, how many do defense / carrier work. And I'm sure there's many of you that do none or a combination thereof. But the purpose of this series is to help all of us. I'm a plaintiff's lawyer. That's all I've done my whole career. It's what I've grown up in. I think you all know that by now. But we do have a coverage practice in our firm. We do some defense when needed. And I've worked over the last 3 decades regularly with defense lawyers and insurance representatives who I consider to be my colleagues, my friends. And you can't forget that that's also from that side, from the defense and carrier side, you have to constantly be looking for resolution. And one of the things that I'm always surprised at as a plaintiff's lawyer is the resistance we get or the pushback or the difficulty in having real discussions of trying to resolve cases with our adversaries on the defense and insurance side. And we have many that we successfully work with early, and that's what I'm going to talk about today and throughout the series. And so those have been wonderful experiences, and I just want to expand that. So as a community, we can all work better on trying to get our cases resolved. Because ultimately, that's what we're doing, right? You sign up a new case as a plaintiff, you get assigned a new case as defense counsel, or you get that file as the carrier. And ultimately, we all want resolution. That's what we're here to do. And we prefer to have resolution without a trial. And there are different parts within the litigation that there's always time to look at and address resolution. So today, we're going to talk about the period of time from when you first get this new case, whether you're on the plaintiff or defense side, and before the case is filed, before a claim is filed in court, usually a complaint, before the litigation gets underway. And that's what we're going to talk about. So to go over a little bit of the house rules, the first is that if you're not an Academy member, what are you waiting for? Come on. I think if you've attended more than 5 of my CLEs, I think that's sufficient enough to see the benefits of a membership with the Academy. Join the Academy. It's very reasonably priced. Michelle will work with you individually or as a firm. And not only will the free CLEs continue, but there's so much more to get involved in and to work on behind the scenes and to grow in our ranks and to lecture in CLEs and to get involved and see what we do as an organization. It's pretty amazing. So I encourage you to join if you haven't already, and just reach out to me or Michelle and we can make that happen. A few more things is that questions, please submit them as they come to mind. Comments, challenges, correcting me if I'm wrong on something, put it all into the Q&A and we will be able to address those. And I'll take all those questions. If I see some during the breaks with the polls, I'll look at it and address them. If not, the CLE is going to go from 1 to 2 today. As many of you know, I stay on from 2 to 2:30 just to address questions and talk things out. You will get additional credit for that extra half an hour if you stay on. So I encourage you to do so. All right. With that being said, let's get into it. All right. So what is the principle here? What is the principle that we want to talk about? And again, that's resolution. We have clients. We're lawyers. These aren't our cases. I'm representing families and injured people. You may be representing families and or injured people, or you may be an insurance claims representative or a defense firm. Either way, you want to resolve this for your client. Nobody likes lawsuits or litigation hovering over them. And ultimately, that's what we're doing here. That's what our job is to get it resolved. So why wait? I hate when I hear from plaintiff's lawyer or defense or carriers, no, let's wait, or yeah, I don't see it that way. Let's wait a year. I always, in our firm's policy, is always to give as much information as possible to our adversary to analyze the case. And I can't tell you how many times we've done that only to get pushed back and say, yeah, we don't see anything here. Sorry, file suit. And then it's after, a year in costs and litigation, an adjuster gets assigned to the file and we start talking and they end up, behind the 8 ball. And oftentimes when you're on the carrier side, you end up paying more because of this delay instead of resolving it early on when you had a chance to do it. Same things with the plaintiff. Sometimes cases get worse as they go on. And if you're given an opportunity to resolve a case early, don't delay, don't wait if it's ripe for settlement. So that's what you want to do. You want to see if it can be resolved early, because a settlement now, this is a bird in the hand, right? You're not spending more money. You're not investing more time. You're not stressing out your clients more. If you can resolve something now, as opposed to filing a lawsuit and waiting 3+ years potentially for resolution. So I encourage you at the outset, when you have a new file, when you have a new case, really look at it hard. Really perform an analysis, which I'm going to help you with that today, what that analysis involves. But look at it and say, is this a case that maybe can get resolved? Let's do this. Let's knock this case off now before spending more time, more energy, more on, if you're a carrier and you're paying lawyers to defend the case. Maybe you can cut down on those expenses. Why pay for your lawyers to litigate for 3 years when you could pay for your lawyers to help you resolve this case promptly before even filing suit? Same thing on the plaintiff side. We tell our clients, listen, if we can get your case settled before filing a lawsuit, you may take a little less to settle it. You've got a bird in the hand. You've got to give discounts. Both sides need to be aware and talk openly about that. Hey, I'm not going to give you top value to settle the case now, the carrier may say, because it's early, but on the other hand, you have to understand on the plaintiff side, you can't expect top value if you don't even have to litigate the case. So these are things that you need to think about. Also, I have been finding personally that the trend has been going in this direction, and I want to encourage that to get this type of early resolution. So just make a note of this. Either write it down, type it down, mental note. Always push for early resolution and possibly before filing a lawsuit. That's what we're going to talk about today. So I've given you a checklist in the materials. I don't screen share. If you've seen any CLE with me, you know it's rare that I do that. I don't go through the materials. These are materials that I may reference, but they're there for you. There's a link that Michelle gave you, so you can download the materials if you don't have them. But I gave you a checklist that I created that I think is really helpful in sort of determining, is a case ripe for settlement? Because as much as we like to settle cases early, sometimes it just is too early and you need more time to evaluate, assess, and know the status of the case before you can properly resolve it. You don't want to resolve a case too early to the detriment of either side. So what are the things that you need to look at to see if this case that you're thinking of may be ripe for settlement? Well, first is you have to have medical records. Both sides need medical records if it's an injury case. All right. If it's not an injury or accident case, but it's a contract case, if it's some other type of dispute that you're working on and you want to see if you can resolve it early, you need all the records. Okay. So in a personal injury case, that's going to be medical records. Plaintiff's counsel is going to need all of them up to date. The carrier and the defendant is going to need all the records. All right. So priority number one in a new matter is get all of the records. All right. If you're a plaintiff's counsel, get them from your client, as many as you can. Then get those HIPAA authorizations signed, send those out. We are always sending for records right away, gathering records. Get all those records and get them over to the insurance carrier. And if there's a defense attorney pre-suit involved, get them over to the defense attorney. But you can't expect a carrier before you file a lawsuit to really be willing to engage in discussions if you haven't given them the medical records. They have to assess the file. All right. So you have to work to get those records and to get them over to the insurance company. All right. So first thing is you want to make sure you have all those medical records. You then want to see whether or not the injured party is still treating, right? Is the surgery scheduled 2 months from now? If it is, then the case probably is a little too early to resolve, all right? Is there more significant treatment? Now, it doesn't mean they have to be done with all of their treatment because some people are going to be treating for many, many years to come. But if the major treatment is done, the hospitalization is done, the surgeries for the most part are done, even if they're anticipating things in the future. If the bulk of the treatment is done and a good handle on what the injuries are in an injury case, then you know, all right, we're ready to do it. But I'm going to give you an example of a case that may not be ripe for settlement. Let's say there's a case involving an automobile accident and it's a rear ender. So you know that liability is there on the tortfeasor, and you can size that up from the plaintiff side or the defense side. But let's say the MRI results are showing some bulges, some herniations, and this just happened, this accident last month, and you're speaking with your client, and the plaintiff's lawyer is investigating this and finding out from the client that, yeah, I'm having pain in my back. I'm going for conservative treatment. I'm not sure what's going to happen. All right, this is the type of case that you really don't want to settle. If you're on the plaintiff side and you speak with your client and they're like, yeah, I've got all this stuff, but there's no way come hell or high water, I'm getting surgery. I'm deathly afraid of it. I'll just do whatever conservative treatment, whether it's therapy or injections or whatever it is. That's all I'm going to do. I'm never going to get surgery. That's one thing. But what if you have a client who says, yeah, I've been treating, it's not working. My doctor says that if nothing works out well, I may want to explore having surgery. All right. So in that situation, you have two potential different extremes. On the one side, this could be a threshold case. For New York State, we have a serious injury threshold in automobile accidents, where even if it's flat liability, even if the defendants concede liability in a rear end accident, if the injuries don't rise to the level of a serious injury as defined by the insurance law in the state of New York, then a case can be dismissed. So what's the value of a dismissible case? It's the value of whatever you can get and get out, right? It could be a couple $1,000s. If it's soft tissue injuries and it's just going to be, physical therapy and treatment, because otherwise, if you don't take that couple $1,000s, then the case can be dismissed. So on the plaintiff side, if I see one of these cases early on, I'm thinking, all right, let's not push for settlement just yet. Let's find out, is more treatment going to be needed? And if I'm the carrier side, I'm thinking, hey, let's try and get this settlement done quickly and for a lower number. We're going to argue threshold. We're going to say, listen, we're happy to, do something here, but otherwise, if you file suit, it's going to be a dismissible case, right? Now, what happens if that plaintiff ends up having to have surgery and they have a fusion surgery? Then you could be talking about a 7-figure case. And in my firm, over the years, we've seen this happen. We've seen cases go from a couple thousand value on a threshold that, wait a second, things have gotten a lot worse and the doctors are recommending serious surgery with hardware and fusions. then you're talking potentially a seven-figure case. So you need to be aware of those situations because you may not want to settle those early. So if you have those situations, you really need to make those inquiries from both sides. Plaintiff's counsel, you need to be on your client. You need to keep following up with them. What's going on? Do you think you may need surgery? If not, then I'm going to try and work and settle your case now before filing suit. I don't think it's worth it because your case could get dismissed. So let's see what we can do. Let's get all the records. Let's get a conversation going with the carrier. If you're on the carrier side and you see this initial assessment and you're like, oh, this looks like it's liability, but it's probably a threshold case, you're going to want to pick up the phone and call plaintiff's counsel and be like, what's going on? Is your client just going to be doing conservative treatment? If so, we're probably looking at a threshold case. And if you want to wrap it up, we can try and wrap it up. I'll put some money on it. Let me know what's going on. So these are the types of things that you want to be aware of when you're looking to see whether it's ripe for settlement. But the same scenario, a similar scenario, let's say it's flat liability, person runs a traffic light, makes a left-hand turn, knocks the plaintiff down, and they have a broken leg. They go to the hospital, they're treated, they're released, they're now doing outpatient physical therapy. Look, as far as I'm concerned, we can all size up the value of that case based on flat liability, broken leg, hardware, surgery. We're going to have difference of opinion on values potentially, but that case, in my opinion, is ripe for settlement because, physical therapy, additional treatment, unless there's really strong indication of another surgery coming down the pipe, then I think those are cases that you want to see about looking to resolve early. The other thing is you need to understand what the insurance picture is. All right. Many of you have attended CLEs, or the CPLR updates. The annual updates with my partner, Rosa Feeney. We have a coverage division in our firm of 3 lawyers that look at coverage issues. If you need that help, let me know. I'll put you in touch with Rosa. But if it's a broken leg and a left-hand turn and it's a 25 policy, why are you going to litigate that case from either side, right? That's a policy case. If it's a 100 policy, but there's also potentially SUM involved, you want to push to try and get that SUM full policy without going to suit. So then you could focus on the SUM part and perhaps get into arbitration. So take a look at the injuries and take a look at the coverage. Sometimes too much coverage can be difficult because you're not just asking as a plaintiff, look, tender the policy, clearly the damages are worth more. It's when there's enough coverage and the injury is enough that there's a lot to talk about that it could be worth early resolution, but maybe not. But you need to look at the whole picture to see if it's ripe. You need to look at coverage, you need to look at injury, you need to look at liability, and you need to look to see if treatment is complete. The ideal pre-suit settlement scenario is going to be if you have a full set of records, treatment, the majority of treatment is generally done, you have clear determination of liability, and you have both sides that are available to discuss. You have a plaintiff's lawyer who's willing to pick up the phone with the insurance company or a previously assigned defense counsel. And you have an adjuster who's receptive as well, a claims representative who's receptive to this idea of resolving it early. All right. So that's initially the window, the lens you want to look through to see if this case that we're talking about is ripe. And you may have those cases right now sitting in your file, sitting on your desk, sitting on your computer, whatever it is, that could be ripe for settlement. And wouldn't it be great after today, you go and you look through, hey, I think this one's ripe. Let's make those calls. I'm going to call up the carrier. If you're a carrier, I'm going to call up plaintiff's counsel. Let's see if we can knock some stuff off. So that's what you should look at first. So one of the things I want to talk about is the initial contact between both sides. And this is something that I've been really preachy about, and I apologize for that. But, we're in an adversarial world that doesn't need to be as nasty as it often gets. Overwhelmingly, the people that I interact with in this profession are wonderful, nice, kind people who are working really hard for their clients and for their firms and their companies. However, We always run into people who are miserable with their job, and those are people that are often miserable with their life. And sometimes you have some pretty uncomfortable conversations. I think it would benefit everybody if you start every litigation interaction with your adversary on a very positive, kind note. There's no reason to start off bitchy or fighting or rude or nasty or flip. The way that cases start off is often the way that they resolve. And it's really important to start things off on the right foot. So here's what I mean by that. When you have the first case, if you're the plaintiff, since we have 43% who represent the plaintiff, when you send that first initial claim letter or letter of representation to the carrier, which needs to go out immediately before you can pick up the phone and talk about it, there needs to be something in writing that you represent the plaintiff. Please provide, information about the policy. Please give me a call. I'd like to discuss the case. Put some details in there. Make it a nice opening salvo. Show them that you're a decent person from a decent firm, and you're letting them know, hey, we have this new case together, and you want to work with them towards resolution. So you always send out your letters of representation first. Make sure they go to the liability adjuster, the SUM adjuster, claims rep. I use those terms interchangeably, and no fault, whoever it is, defense counsel, and then pick up the phone. Even though you're asking them to reach out to you, pick up the phone. Hey, Michelle. Oh yeah, I see this case was assigned to you. My name's Andrew Smiley. I'm representing the plaintiff. I sent you a letter of representation. It should be in your file. Did you have a chance to look at your file yet? Would you mind pulling it up? I wanted to, contact you and just touch base, make sure, see if there's anything you need. That's the type of call that you'd be amazed how well that works. And if we were to do a poll of how many people do something like that, I bet the percentages would be pretty low. So that's the first start, is you're throwing out the olive branch from the plaintiff side, and you're trying to reach out to the claims representative, the adjuster on the case to have that conversation. Now, if you're on the claim side or defense side, do the same thing. Pick up the phone, call the plaintiff's lawyer, say, hey, I got your letter. I want to talk about the case. Do you have a few moments? Get that information, get background information that you may not have. Are they still treating? How are they doing? It's okay to be nice. Are they still in the hospital? Do they have any surgeries planned? Have you got medical records? Do you have the police report? Send me everything you've got so I can evaluate the case. All right, that's what should be happening.
Attendance code number 1 is WBY 276. That's WBY 276.
And if you can establish that rapport, it will really benefit you, because perhaps you can get this case settled before filing suit. If not, then we'll go on to part 2, okay, which we're going to talk about next month, filing the complaint. But you got to give it a good shot of trying to get that rapport going. And sometimes you'll get someone who doesn't return those calls, okay? Sometimes they won't respond. Sometimes you leave those messages. And if you don't get a response to the phone call, see if you can get an email address. Then send an email. Hey, I've tried to call you. Can you give me a ring? And look, if after a while you just get blown off and you don't get a response to your phone calls and your emails, unfortunately, that's a sign that this is just not going to be one of those cases that you could resolve, and you've got to put it into litigation. All right? But by getting a response, you'll be able to get a sense. And a lot of the claims people I speak to, and I hear of the lawyers of my firm, when they do this, they get really good feedback. Hey, I had a great call. They want to try and move the case. They need everything. Let's work on it. And then stay in touch. Keep each other posted on what's going on. Get that rapport going. All right. And if you can get the rapport going and that pre-suit settlement checklist, you're checking all those boxes, give them everything, make sure they have what they need to evaluate the case, and then you've got a really good shot at settling it, and you've got that rapport established. Now, sometimes you may be too far apart. You've given them everything. Everyone's really nice, but you think the case is worth $1 million and the claims adjuster thinks the case isn't worth 6 figures. So what do you do there? You try and talk it out. It's important that I believe that we all acknowledge each other. I'll often say to the carrier, look, I hear where you're coming from. I'd probably argue the same thing. Let me try and convince you why I'm seeing this case differently. Okay. And if you're the adjuster or claims rep or defense counsel early on, say the same thing. I see where you're coming from. I don't blame you, but we just don't see it that way. And we're open to resolving the case early, but if you're looking for 7 figures, there's no way we're going to get there probably ever, even if you're looking close to it. But if you're open to maybe something in the high 5 figures, if you want to speak with your client, let me know. And so try and get those conversations going. What I'll do is talk about alternative dispute resolution if we can't settle the case early. Okay. And that's the next thing I want to talk about is throwing out, hey, why don't we try and mediate this case before putting it into suit? So mediation's an option. Binding high-low arbitrations are a great option that a lot of firms on the plaintiff side don't think about. A lot of firms on the defense side don't either. And when we throw that out as a potential way to resolve a case early on, sometimes we get good response. Hey, that's not a bad idea, right? Especially if it's a case where, let's say, the plaintiff's attorney evaluates the case at being worth $100,000. Let's say the carrier sees it as being worth maybe $1,000 or $25,000. And let's say it's a $300,000 insurance policy. So if on the defense side, they're seeing this case as $2,550, the plaintiff is looking for $100,000, it's a $300 policy. Why are you going to litigate this for 3 years, spend money on both sides to get experts or doctors involved or narratives or litigation costs, depositions? Why don't you agree to a high-low arbitration or mediation? The mediators could probably knock some heads together, get the plaintiff to see, well, maybe the case isn't really worth $100,000. Maybe get the carrier to see, maybe it's worth more than $50,000. Maybe the case gets knocked off for $75,000 or $85,000 in a mediation. The client's thrilled. Everybody's happy. It's done early. Obviously, these numbers can change, but you get the idea. What's good about a high-low arbitration early on is the carrier is getting ceiling coverage. So if it's a 300 policy, maybe they'll agree to a high of 250 under the scenario and a low of maybe $25,000. So this way the plaintiff knows they're going in at least at 25 grand and the claims rep in defense knows, hey, we know we're getting in for less than the policy. And then if we all feel good about our positions, let's agree. You can do it with private arbitrators. All of the mediation and arbitration companies that sponsor the Academy are fantastic, and Michelle can fill you in on those. And you can agree, find one that agrees to. Not all mediators will do arbitrations at the private companies, but some do, and some are known. They're happy to do high-low arbitrations. And that's another great way to get cases resolved with certainty. And again, the importance is explaining it to your clients on both sides. If you've ever seen one of my lectures, you know that I think it's really important to inform your client. My 2 mantras, right, are preparation, 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 and inform your client. And this is on both sides. So on the plaintiff side, I'm having that conversation early on with my clients. I'm saying, look, there's a chance we could resolve this early. And here are some things I want to propose to you. I explain how the high-low works. I explain your case can be wrapped up this year or within 3 months, as opposed to waiting 3 years. This is what I'm thinking of parameters. This is what the arbitrator will probably come out with. Or if we go into mediation early. You have to understand, if you think you're going to get top dollar, that may not happen. We've got to give discounts. It's early on. It's allowing you to get bird in the hand money now. If I could get you $85,000 now, instead of waiting 3 years to get $100,000, I think that's worth it. Our expenses are going to go up. You'll have the use of your money early. Same way on the the defense side or the carrier side, you need to tell them, look, why wouldn't you want to knock this off now? Why are you going to pay a law firm to litigate for 3 years, pay all the expenses, if you could knock this case off now and save that? So it takes people to think outside the box a little bit, but a lot of lawyers are willing to do that. So ADR, alternative dispute resolution, is really, really something that you should consider doing. Mediation, binding high-low. And this is something that you should always be proposing from both sides that you're on. If you like to get your cases resolved, and I don't know why you don't. That's what we're here to do. Reach out. Hey, is this something maybe you want to settle straight up? Maybe we should mediate it. Maybe try a binding high-low arbitration. Let's see what we can do. And so if you do get that initial warm enough response from your adversary to resolve it early, that's a great way to do it if you can't do it straight up, meaning just on the phone, working settlements by phone calls or texts or emails. I did settle a case this past year by email, and it was wild. By way of sharing this, it wasn't a pre-suit case, but just to show there are ways I could go. I had gone back and forth and having a hard time getting through to the defense lawyer in the litigation. And he asked me again for my demands and to put it in writing. And then he responded with a number and a question mark. So I responded with a number and a question mark. Then he responded with a number and a question mark. And it went back and forth like this for basically a day and a half until we agreed. And it was wild. It was literally like a number and a question mark. So you could settle cases in lots of interesting ways. All right. But look into alternative dispute resolution. It is the new wave, folks. I would much rather resolve a case with mediation or arbitration than letting a jury decide it, letting a judge decide it on motions, litigating it for 2 years, even getting verdicts. You're getting them appealed, cases get thrown out. There's so much uncertainty that if you can get that certainty through alternative dispute resolution at some point in your case, and certainly today we're talking about early on, I think it's really important and you really need to do it. All right. Now, again, this all is assuming that you can get through to somebody and you could have this back and forth. If you can't, then you're going to need to file suit. And there's some times where early resolution, even if it seems like it's ripe, just may not be right. And we're going to talk about those situations in a moment. But again, keeping your client informed and setting expectations is super important. Super, super important. Explain your thought process to your clients. And this should always start with the minute you sign up the case, the minute you get handed the file, you need to have a good communication with your client. And you need to let them know what you're working on. Hey, I'm getting the records. I'm trying to see if I can get your case resolved early. If you're on the defense side, hey, I'm working with plaintiff's counsel. I'm trying to see if we can get this one knocked off early so you don't have this hovering over you, okay? Set expectations properly for both sides. Let your clients know you're never going to settle their case without speaking to them, without their consent, because some clients don't know that. They'd be like, hey, are you just going to settle my case? How does this work? So you always need to let them know that it's a process of interplay with you and the client. You're going to give them your input. You want to make sure they know all the upsides and downsides, whether it's going to a mediation, whether it's settling early, what numbers to settle for. Let them know that it's a process that is interactive and you're constantly going to keep them informed and you're going to tell them the pros and cons and let them decide. Sometimes you'll have a client that wants to settle a case early, even if you're not interested, depending on what their reasons are. All right. So you need to have that conversation and let them know that they have that opportunity and what the pros and cons are of early resolution. Also, make clear about what your plan is as a lawyer. Maybe, they're sitting at the dinner table in the holidays, the plaintiff saying, yeah, I haven't been questioned yet in a deposition. And someone says, well, has your lawyer even started a lawsuit yet? I'm like, I don't know. I don't think so. I'm not sure what they're doing. That's not good. Make sure you let your clients know what you're doing. Say, hey, listen, I just want to let you know what we're working on. I think we may have a shot at resolving your case early. And I think it may be worthwhile to do that before filing suit. Here are the pros. Here are the cons. And this is what I'm working on. I've been waiting on you to make sure that you're telling me that you're done with surgery, you're done with treatment, getting the records. So make sure you never want a client wondering what's going on. Why haven't I heard from my lawyer? Why aren't things getting done? Because you are working, you should be working, you should be keeping them informed, you should be giving them copies of your correspondence, CCing them or BCCing them on your emails, on your letter requests, things you're doing. So there's no confusion and that they understand what's going on. Really, really important. Always keep your client informed. All right. So when are the situations where look, I tried. I went down the checklist that Smiley told me and gave me to do. I think the case is ripe. Treatment is pretty much done. I've got all the medical records. I'm speaking with the adjuster. So far, so good. But when is it it's not going to happen? So a couple things to think about. Sometimes you just want to get that lawsuit commenced and filed right away, no matter what. And these are cases, there's two instances where you're going to need a court involved no matter what. You're going to need to jump into the litigation system, the court system, no matter what, even if you come to terms early on a number or on a settlement. So a couple of those that may push that dial one way or another towards early settlement or filing suit. Infant cases. If your client is under the age of 18, it doesn't look like they're going to be turning 18 anytime soon in the next year, and you think you may get close to resolving a case, you are going to need a court to provide you with an infant compromise order. It's a process of submitting petitions and affirmations to the court, having the infant plaintiff present to the court in person or via Zoom or phone or however the judge wants to do it. But you cannot settle a case of someone under the age of 18 without court approval and without going through that process that involves getting an infant compromise order. I've included information on infant compromise orders and what's needed in the materials. So that's one instance where you're going to need to go to court anyway. So you may want to file a summons and complaint, keep that pressure on, keep things moving in the right direction. And this way you could just file a request for judicial intervention if you haven't had issue joined or a preliminary conference yet, if it's still early on, or at least you've got the case moving forward where you're starting the litigation, the clock has started moving, things are moving forward, and if you can continue to work on settlement, then you have a judge assigned, you're in the system, then you can file your application for a infant compromise order. So that's one instance where most likely you're not going to want to waste months and months and months trying to cultivate a pre-litigation settlement. My recommendation is let the carrier know, hey, I appreciate it. We've been working well together, but, I have to keep moving this case. I'm going to have to file an infant compromise order showing the work that I've done on behalf of the infant and my law firm's done. I can't just sit back and do nothing and wait. If we could resolve it right now for a good number, then that's great. I'll just file an order to show cause, and we don't need to file suit, and we'll just submit an infant compromise order. That's great. But if not, I'm sorry, I've really got to file the lawsuit and keep things moving. All right. So that's what you do in infant cases. That also will happen in a death case. All right. When there's a death case that you're trying to resolve, unless you have unrestricted letters testamentary, which usually you only get from probating will of the decedent. In our world, in wrongful death litigation, overwhelmingly people pass away without a will. So you're going to get letters of administration. You're going to need to get a wrongful death compromise order. You're going to have to go back to the Supreme Court and most likely surrogate's court. It's going to be a long haul. Even when cases are settled with, getting a wrongful death compromise order, you could be taking 6 months to north of a year to bring it home. So you might as well get that ball rolling, get the case filed, get it started, and get things moving in that direction. I've also given you that information about wrongful death compromise orders in the materials. And again, you're going to want to get the ball started, rolling if you need to get letters of administration for the family to move forward. So in death cases, those are really, really hard to resolve really early. So you may just have to start the litigation before settling those cases in a wrongful death case. So I would encourage you to look at that. And then a couple of other reasons that I would suggest that you should probably move ahead and file suit. One may be that your client is a little iffy if you're a plaintiff. You know, they keep saying, well, I've got someone telling me I should go to this other lawyer. You know, if it's just on shaky ground and you feel there's a chance it's a decent case and the client is something doesn't seem right and they may leave you, if you file a lawsuit, that will give you an automatic lien against the file for the work you've done. That's under the judiciary law, section 475. So I gave you some information on that in the materials as well. So in order to protect the work, if you've done work already and you're worried that this client is shaky and may split on you, you don't want to spend too much time trying to cultivate a pre-suit settlement. You should definitely file suit to protect your lien. Because if you haven't appeared in the case, the materials talk about what that is, basically filing a notice of appearance, filing a complaint, appearing for a mediation or starting that process going, filing a petition for arbitration, then you don't have a statutory lien as a matter of right. So you could be doing a lot of work on the case and then the client leaves you high and dry. So you may want to consider filing a suit under those circumstances. Also, look, like I said earlier, if you have an unresponsive claims representative or one that is just, you feel like you're just talking to the wall, then just file suit because otherwise you're just wasting your time. And sometimes it's better to file suit if you've accepted the fact that it's probably not going to get resolved before that because the claims representative is either not very responsive or nice or whatever the reason is. You can't have good conversations. Sometimes by filing a lawsuit, you'll get a new adjuster assigned. And sometimes we find by filing the lawsuit, that's the little extra push that gets us from the pre-suit resolution that's not happening to our chagrin to getting it resolved by filing the lawsuit that does it. And filing a lawsuit doesn't mean you're going to war. It doesn't mean all bets are off. You can still use that to activate and help settlement talks. We have a case in my firm now that we're working on that the insurance representatives have said they will settle it. It's a rear end case. It's significant injuries. And then every time we started to get close and have conversations with them, they're like, no, we're really not because we don't have this. We're going to need a narrative report from the surgeon giving causation. So we get a narrative report from the surgeon that gives causation. And then the adjuster says, well, I don't know. And we're like, look, this isn't really right. We've been talking about this for months and you keep telling me you're ready to settle the case. And we've set up phone conferences at your request. And then you tell me you want more. And then when I give it to you, you're saying it's not good enough. I'm really sorry at this point. We have to file suit. Hopefully we can keep the conversation going. So we did. And we filed suit. And they said, no problem. We understand. Maybe that'll help us. We can have our defense firm that we retain provide us with their analysis. And so that's where we're at now. And it turns out it's a firm that answered, that we've done, had a lot of cases with and resolved cases. So I was pleased to see that. And I said, look, maybe now you can help. And we're working now with the defense counsel and the insurance company to continue the talks. And basically, if it's not going to get resolved this month, we've told them that, look, we're really trying to resolve it. If not, we're going to file for summary judgment. It's a rear end case. We want to get interest running, but we'd much rather resolve it. So that's sort of a tool that you can use to help move things along. All right. So let me try and take some questions right now because I like them. And I think that they're important that we talk about in this first hour. If we start to run out of time, I'll continue on. So the first question that I see is from Elena. Hey, Elena, nice to see you virtually here. Elena's question is, do you need to file a summary judgment motion on the issue of liability before you push for early resolution? Absolutely not. So that's the example that I gave. Many times an insurance representative will say, yes, we're accepting liability, but we need to look into the damages to evaluate the case. And what they mean by accepting liability, it's usually when it's a rear end accident and they know that they're going nowhere. So you don't need to go to court. You don't need to file a motion at all. You can always push for early resolution, even if you're not in the litigation itself. And that's the example I just gave of how we're going to use summary judgment as another lever to get settlement talks. We said, listen, if we can't get this case resolved this month, we're going to move for summary judgment and get interest running. So we're using that as another tool in our toolbox, which you should always be thinking about. What tools do we have to bring this case to resolution? And summary judgment motions are one of the most effective tools because as a plaintiff, you may get judgment on liability, and then it's a matter of how much an interest runs. If you're on the defense side, you could get the case dismissed on summary judgment. So while those motions are pending, are usually really good times to get cases settled. All right. All right. William is saying, what sources do I use to value damages? There's lots of sources. I mean, I have a little bit of a benefit because I've been doing this for 30 plus years. So I have a general idea. But the first start, and what I talk about in my books, a little plug to my How to Successfully Litigate a Personal Injury Case, is on Amazon with Successful Trial Skills. What I always talk about is you have to do the hard numbers first. Those are economic numbers, medical bills, loss of income, future medical care. Get that sized up first, and then that gives you the base. And then above that, you look into the pain and suffering. You could look at the New York jury verdict reporters. You could do searches online. You could do searches with Lexis, Westlaw. There's lots of ways. AI can help you with it. So there's lots of ways. You can bounce things off of other lawyers or me to find out what we think things are worth. It's not a science. It's an art. All right. Mark. Not all of us do personal injury work. I've been a commercial litigator for 40 years, so it can be on either side of a commercial dispute. Thank you for pointing that out. And I don't want you to think that what I'm talking about is solely personal injury. It's what I do primarily, but early resolution can be for anything, right? Even in criminal cases, that's what plea deals are all about. So my recommendation to those of you who do commercial litigation or other types of work, if there's a V in it, plaintiff versus defendant, it's a litigation, it's a dispute. Always push for early resolution. So in your commercial dispute, it may not be, looking, and it likely won't be looking at someone's treatment and their medical course for assessing damages. But if it's commercial litigation, people are suing each other for some reason, and it's usually for money. I see a question about injunctive relief. Lei Song is asking, how does it work if it's an injunctive relief or a blend of injunctive and money damages? Look, if it's money damages and it's commercial litigation, plaintiff is saying defendant owes the money. Usually the big dispute there is how strong are the contracts? What's the proof that you have as far as damages? So you need to work on that. All right. If you're the plaintiff, you're reaching out to the defense. Hey, this looks like a strong case. I'm going to give you everything I'm working on. I'm going to give you our memo of law. I'm going to give you our assessment of damages. And if you see something different, let me know. But maybe we can resolve this. So it's the same process, even if the subject matter is different. Usually litigation involves damages one way or another, or a decision of who's at fault or more at fault or who's responsible. There are ways, it's whatever it is that you need to evaluate that you want to have that discussion with. And you want to give the other side, if they're going to need to evaluate something before they can agree to any kind of settlement terms, you're going to want to make sure that you give them what they need, and you're going to make sure you get from them what you need. That's really the key here. And that's why it's really important to establish a rapport. Sometimes you get adversaries that are happy to work with you. Sometimes you get some that are like, no, and they just put it in writing, and they don't answer the phone. And that's what gets frustrating in litigation. All right. So yeah, all of the things I'm talking about can apply, whether it's personal injury, commercial litigation. Now, injunctive relief is different. Injunctive relief, you generally will need a court to issue an injunction, right? You can't issue your own injunction. However, if the injunctive relief you're seeking is something that potentially could be agreed upon by both sides, then you could approach that. Hey, would you agree to stipulate that at least for until something else happens for the next year, you're not going to do this. We're not going to do that. Whatever it is that you were going to ask the court to do, you can always try and see if that's something that can be hammered out. Sometimes you can't agree. Technically, you need a judge to issue an actual order, or if you, like I said, if you can stipulate to some type of relief and then put a so order line in. Those are ways to do that as well. Okay. All right. Arjula is saying that she agrees or he agrees. Mentor always says, pick up the phone. We do mostly commercial litigation. Yep. Pick up the phone. It's amazing. And as my partner Jason says, you can never read tone into email. Sometimes you get emails or you think your adversary is being nasty or short or rude. And then you get on the phone and you realize they're really nice people. And you find out that you have some things in common and you get along. And maybe you both can agree to work it out. So pick up the phone is easy to say, easy to do, but not everybody does it. Teresa is saying she's never, in caps, had a positive call from or with the opposition, and that you always advise other attorneys and clients to communicate in writing. So look, that's been your experience, and it's unfortunate that you've never had a good conversation. That's really sad to hear because it's important to have these and to pick up the phone. I still believe in it, but it's also important to follow up in writing, right? So follow up in writing. And if you don't get through, I mean, I write emails to people. This is my 4th email and I've left you 3 messages. Can you at least do me the courtesy of acknowledging me? It's very frustrating. I'll often say things like that. All right, if I don't, then, I'll have to litigate or I'll have to file a bad faith letter or whatever it may be. But you still need to make these efforts, in my opinion. All right, Yandy is asking, can high-low be done in mediation or only in arbitration? All right, so let me be clear about the definitions. High-low is only in arbitration. If you think about it, if you agree to go to mediation, it's always a non-binding mediation. Both sides meet with the mediator, see if they can hammer something out. If they can't, at the end of the day, you go your separate ways. That's what mediation is. Arbitration, by definition, is you are allowing somebody else to decide how this case is going to resolve, what the number is, what the terms are going to be. They're going to decide it. So the high-low is only done in arbitration format. You are agreeing that this is it. No appeals. The arbitrator is going to decide. And if the number falls between the high and the low, that's what you get. The number falls below the low, you get the low. If it comes up above the high, you get the high. That's how it works. Okay. All right, it's 2:00. I see that we are over. I apologize. Nobody told me. So I'm going to continue going through the Q&A now. We'll be back next month, February 18th, for part 2. And in part 2, we're going to talk about the next steps, filing the complaint. Who are you going to name as defendants? Where are you going to file the case? What are these things that are going to make a difference in the prospects for future resolution? Where you litigate and who you have as defendants and who you have as plaintiffs, it makes a difference in your forum, your venue for getting cases settled. So we're going to talk about that next. If you can stay with me, please do. If not, thank you so much for joining me. You can always reach out to me by email, one-on-one, whatever you need. I'm always here to help. Having a hard time understanding the benefits of a high-low agreement. Can I explain it a little bit more? So hopefully I just did. So here's how a binding high-low agreement works. I've got an injury case that I think is worth $100,000. There's an insurance, let's say I think it's worth $150,000. There's an insurance coverage policy at play that's $300,000. That's it. All right. My adversary doesn't think the case is worth $300,000. I keep arguing. I think it is, but I'll work with you. And then they say, well, we don't really mediate because this and that. We would want resolution. And you say, how about this? How about we agree to a high-low binding arbitration? We'll agree to cap you at $300,000. And you agree to give us a low of $50,000. And we'll let the arbitrator decide the value. The arbitrators are supposed to be blind and not know what the parameters are. You present the case to the arbitrator. The arbitrator knows it's there. You've agreed that they decide the value of the case. You go in, you argue, and I say, I think this case is worth $500,000. Again, the arbitrator doesn't know the high low. They don't know the policy limits. I know that the high is 300. My adversary, we all know the low is, I've offered is 50,000. All right. The arbitrator may come back with a number. That number can be, let's say if we agreed the parameters were 300 high, 50 low. If that arbitrator comes in with a number, says, I think this case is worth $100,000. Boom. That's it. All parties have agreed. If it's a number between the 50 and the 300, the case is done for that number that the arbitrator decides. If the arbitrator comes in with 290,000, that's the settlement number. If they come in with 51,000, that's the settlement number. But here's the kicker. If they come in with 500,000, we've agreed that the high is 300. So we get 300, the plaintiff. Let's say the arbitrator says, no, I think this is a threshold case. I'm awarding zero. We would get that $50,000 because that's the low. All right. So that's how it works. But either way, this case is resolved. So you're explaining to your clients the high and the low and the guarantees, basically. And that's how it works. That's a high low. So it can be very effective, and it's a guaranteed closure and settlement of the case because a mediation is not a guarantee. All right. So that's the difference. Hopefully I've explained it, Kenneth. If not, please let me know if you want me to discuss it further. Christopher is asking, any comment on chasing above policy cases? Do you chase the assets of defendants? That's a great question for what we're talking about, and another consideration that I didn't mention. So oftentimes there will be a scenario where you, in your evaluation as a plaintiff, believe that the case value is worth more than the insurance policy. Then the question and the insurance policy has been offered to settle, what we call tendered. So here's a scenario of a case we have right now. We have a client who is crossing the street. Defendant made a left-hand turn, took our client out in the crosswalk. Client was hospitalized with multiple fractures of the pelvis, the legs, the arms, had lots of surgeries. It's a $100,000 policy. Early on, we sent the records and we requested all the insurance information, to which we received a response. There's only $100,000 in coverage. We are tendering it based on the liability and the medical treatment. We're offering you 100. Here's a release. Sign it. And the case is settled. There's no excess. We got the affidavits of excess. There's no coverage. So we believe the case is worth more than 100,000 based on all the injuries. So we look into the assets and we look into who the defendants are. And we see whether or not we think there's anything recoverable. Sometimes you can do it just on a Google search and you look up where they live, you look up if they're working, you do your own investigation and try and find things out. And you see, oh, these people, they don't look like they have any money that would be able to pay above a judgment. But sometimes in the case that we have now that I told you about, we found out that it is a couple that owns the vehicle, that both have decent jobs. We learned through, I'm not sure how we learned through, maybe through their own lawyer, but we learned that they have kids in private school and they are just not agreeing to offer a dime more than the policy, which we've explained to our client, the up and downside, if you want to wait in the litigation and see, and our client is upset. It's not my fault that they don't have enough insurance. Why should they get off easy? So in that instance, we're pushing towards trial and see if they come up with more money to resolve the case or not. But we've also had a case where we had a case once where it was a car accident and the client was rendered quadriplegic. And it was a $50,000 policy or a $25,000 policy. And we did our homework and find out, the driver of the car, it was an old beater of a car. The client doesn't have a job. It was the minimum insurance. We're going nowhere. We have no choice. We're not getting any more money at the end of the day, even if we got a $20 million verdict. So it depends is the answer. It depends. And I'm happy to talk out that more thoroughly with you. If you really think there's a potential to get more above the policy, that your likelihood of getting above the policy limits at trial is very certain, almost as certain as it could be, and the potential to recover damages, then you go for it. If not, then sometimes you got to take what you get and keep on moving. All right, Joel, how are you? Haven't I found that some defense attorneys don't want to settle early since it affects their billing? Some defense attorneys always want to pick a jury and then settle. It's all about billing. It's a good question as well. Look, that may be the case, and we've talked about this. I've talked about this a lot in my CLEs. Most defense lawyers will tell you that they want to just do a good job for their client. And the client's happy to get it resolved early. And if the client's happy, they're happy. And the client will keep giving them business, so they don't need to bill. There are lawyers, though, who say they need to work up the file. They need to bill the file. I don't like hearing that. I mean, everyone's got to work and do their work, but not just for the sake of working. So, yeah, I mean, you do hear that sometimes. But if I get that vibe that a defense lawyer is solely just trying to bill and work the file, and that's why the case isn't settling, then I'll go straight to the carrier, and I'll contact the carrier and say, why are you continuing to pay your lawyer for this when we can resolve this case? And I'll let the lawyer know that you do or don't have to. There's nothing wrong with contacting a claims adjuster directly, as my partner Rosa has lectured under the insurance disclosure law, the comprehensive insurance disclosure laws in New York State. Under the CPLR, you are required to demand and be provided with the full policy, as well as the claims adjuster's name, contact information. So demand that, contact them. And that's what you do, in my opinion, if you feel that you've got a defense lawyer who's milking the file when it's a case that should be resolved. And then look, sometimes I've done that. And then the claims adjuster will respond to me, please have all settlement negotiations and talks through defense counsel. And then you're stuck. There's nothing you can do until a new one gets assigned, a new adjuster, which you hope happens sometimes. Vincent, thank you for the nice compliment. Okay. John, thanks for joining. Maybe some of these people put their questions in or comments and then split. All right, Alan, how would your information translate to a non-personal injury case? For example, an IP case in federal court, intellectual property. All right, so it depends, again, on what the subject matter is. If there is a litigation, it means there's a dispute, right? If you're in court or you think you're going to federal court. So Alan, if you're handling an intellectual property case in federal court, what's the issue? Is it someone feels that someone's stealing their brand? Is someone suing saying that they stole used the license or lyrics to a song? Whatever it may be, maybe there's stuff that can be agreed upon. Why do you want to go to court? I've heard of these cases that have gone to court. There was a famous one where someone took the riff of a Marvin Gaye song and used it for their own. And there's a lawsuit from Marvin Gaye's estate saying that the person that made the song generated millions of dollars using copyrighted music from Marvin Gaye. So let's say that's the type of case and it's being litigated. Instead of waiting for a court or a jury to decide, yeah, you owe millions of dollars, why don't you see if you could work something out in those? Hey, we feel we didn't do anything wrong. My client does, but they acknowledge maybe we could come to terms on a settlement. Okay. So again, always, whatever it is, if the only way to resolve the case, if you can't come to terms, is to go to court, then it means there is an issue in dispute. So try and get it resolved. Pick up the phone. I think that's today's motto. Pick up the phone. Joel, did I ever find that carriers will pretend to want to settle a case they have to set up the reserve fund so getting the meds helps to do that? Yeah, so here's what we'll often get. We're always pushing settlement throughout the litigation. That's what this program is about. Even if we can't do it before suit, once you file suit, continue. We're going to continue trying to push these cases for settlement throughout this whole series at each of the phases of the litigation before trial, right? So sometimes we'll reach out and say, hey, don't you want to mediate this case? Can we talk settlement here? What's going on? I think this case should be settled. Don't you? Do you really think you want to go to a jury with this? And then many times we'll get, well, you've never given us a demand. I want a demand. Or sometimes we'll just get out of the blue a call from defense counsel, the carrier. Do you have a demand on this case? And here's the response that we give. We will say, well, why are you asking for a demand? Do you want to settle the case? Is that why you're trying to look at, or are you just asking for a demand to set the reserves on the file? Is it just part of your checklist? Has the plaintiff given a demand? Why are you asking? We'll give you a demand, but we're only giving you a demand if you indicate to us that the purpose of the ask is to move towards resolution. That's how we handle it. I don't like just putting numbers out there. And then they say, no, the carrier really wants to resolve it, but they'd like a demand because your demand may make the difference. Then we sit tight and we formulate a demand. We look back, we evaluate the case, and then we say, all right, we'll give you a good demand. Then we'll get back to it. We'll say our economic workup shows they're going to need $1.2 million in future medical care. We see that their loss of income is going to be probably about $700,000. And there's pain and suffering. So based on that, our demand is $2.5 million. And they may say, well, that's crazy. Based on that, I don't think they want to resolve it. Say, all right, look, we're giving you the reason. That's all we can do. But I think that sometimes, they're going to try and feel out where you're going with the case. So I always like to couch it. I don't just like giving demands for demands. I will only give a demand if I have a true feeling that it is moving towards settlement. All right, Susan, I'm relatively new to defense work, so this question may seem strange. No strange question, Susan. I've been astonished by a weakness of a couple of the cases that have come to me. I have an employment case right now claiming harassment, mental anguish. Plaintiff's lawyer has turned over 0 documents, a couple of recordings. Further, there's no medical. To me, this case is worth nothing. But the carrier probably come through with a few thousand for plaintiff's perceived suffering. Is this unusual? How'd you deal with a case like this? All right, great question, Susan. So we had a similar situation because our firm does coverage work. We were handling a case where somebody was sued. I won't bore you with the details, and their carrier disclaimed. And so our firm was fighting to get the defendant's coverage, which is what we have 3 full-time lawyers in my firm work to do. And in the meantime, we'll provide a defense until we can try and get coverage in or get defense counsel to do it. So we had this situation, and we're reviewing everything in one of our firm case meetings. And it was fun for me to see what another plaintiff's lawyer is trying to do. And the coverage lawyer from my firm is saying to me, well, they think that it's a big case, and they're telling me they gave me a demand, and I've asked them for a demand, and they're not giving me a demand, and they haven't given me any medical records. And I said, listen, this sounds like a bunch of bullshit to me. I don't think this is a viable case. I think they're going nowhere here. And this person's puffing out their chest that they think they have a case, but they're not giving you a demand. They're not giving you any medicals. Tell them you're not going to talk to them anymore until they give you something. And the lawyer in my firm, based on what I've said, kept saying, give me a demand, give me medicals. Well, I'll give you a demand. I think this is a 7-figure case. All right, give us the medicals. And we have to look at those. We have to see if they give causation, what the injuries are, and they wouldn't even give the medical records. And to me, it's just nonsense. And look, I think that, like you said, Susan, there are going to be lawyers out there that are going to think they send you a letter and they're going to get paid, which is ridiculous. So you can very nicely say, and what I would respectfully suggest you do is say, listen, you're giving me nothing to work with here.
Attendance code number 2 is WBY329. That's WBY329.
If you've got a case, you got to give me something here. I'll speak with my carrier. They're always want to resolve it, but I need medical records. I need your theories of the case. Give me something first to look at, even if you don't want to give me a demand. But if you're not giving me anything, there's nothing that I'm going to be able to do for you, whether you file suit or not. So I think that you need to do that, because I am often surprised. There are a lot of plaintiffs' lawyers out there and a lot of nice people that just don't really know what they're doing as well, or maybe they're dabbling in personal injury law. when it's really not their wheelhouse, so they're not sure how it works. So it's not unusual is the answer. And if you are a claims rep or your defense on a case and you've got a plaintiff's lawyer puffing out their chest and making veiled threats, I don't know what they're doing. Just keep it cool and say, look, I am all about resolution, but you got to give me something to work with here. Otherwise, I can't help you and your client. This is what I need. Get it for me. That's the best way to handle that. Hopefully, I answered your question well. Matthew, what's happening, man? On picking up the phone, sometimes not returning multiple calls is an answer. So, if, like I said, if you're not getting callbacks, there you go. But you need to call people back, make sure you're not the problem. If you've got a claims adjuster reaching out to you, you got a hot one, you got a lead. It's like you got a fish on the hook. Call that adjuster back, reach out to them. There are a lot of claims adjusters and defense lawyers out there that are proactive. They've listened to me or to somebody and they're picking up the phone. Hey, Mr. Smiley, I just got your letter. Can you give me a call? Don't blow those people off. Call them. Start that rapport. That's always a really, really good sign. We as lawyers and as claims representatives return calls, okay, within 24 hours. Return emails within 24 hours. If you can't do it, have somebody do it. Have an assistant, a colleague say, yeah, Andrew was stuck all day in a deposition today. He didn't want to think you're ignoring him. Is it all right if he gives you a call tomorrow morning? It's an easy thing to do, and most lawyers don't do it. Be amazed how many lawyers don't have the decency, in my opinion, to just acknowledge an email or a phone call. You got to do that. All right, Russell, what are resources that I am aware of to find out about a potential defendant's insurance coverage? This is really tough. We've been asked that you can't always find it. And I'm not sure. I know Rosa, my partner, has talked about this. I think there are, for some commercial entities, ways to find those things out. I don't have the answer. If anybody here has that answer, please put it in. But I know it's only in limited circumstances that you can really find it out. That's why, for my friends on the defense side, you have to, under the Coverage Disclosure Acts, under the CPLR, you have to advise the plaintiff of, and they don't even need to serve a demand. It's on you, defense counsel, under the law in New York civil practice, that you have to give all potential applicable policies that could be in play in the case to the plaintiff. And if you don't do your due diligence and look for excess or other policies that may be involved, there could be a commercial policy for an individual auto case. In addition to the auto, there could be all kinds of stuff. Then you could be on the hook for malpractice, because if it ends up causing problems down the road, which it will, you could be on the hook. So you really need, the first thing that I suggest is press on your adversary if you're in suit, to get all the information as far as coverage. Otherwise, do some homework to find out other ways to find it. It's not always easy. Sometimes you have to rely on others. Okay, Arjula, when I was ignored by an attorney in New York since May, I went to the firm's website, copied everyone in there, and had an angry response in 3 minutes. Good call. We'll do that too. I'll reach out to a partner in the firm. I'll see who the managing partner is, and I'll say, listen, your partner, your associate, below are 3 emails from the last 3 months or for the last year. And you know what? Get that angry response and say, you know what? I'm really sorry. I'm sorry you're upset, but all you have to do is acknowledge me once in the last 6 months, and this wouldn't have happened. So it's on you. All right? Good for you. All right, Melissa, thanks for the nice comment. Nicholas, how do I feel about carriers in the early stages that ask for a statement from the client or authorizations? I have my opinion, but want to hear yours. All right, we don't give clients statements. If they don't have enough, and based on what we've given them, if there's a rear end automobile accident and they have the police report and they've got all the medical records, I'm not giving them a statement. They don't need a statement. Sometimes I feel those are the check boxes things, or things they do to push things over the edge for them, or to drag it out. So in general, my position is, you want a statement, we'll go to court and we'll litigate and you'll get a deposition. You're going to let me sit down and have a statement of your client? Okay, if we both agree to let each of us talk to the others, to the insured and the client, I might be open to it. If I have a good rapport with the adjuster and they're like, listen, we see this as a significant case. I'm ready to talk turkey. The only thing, and I'll agree to mediation. I'd really just like a statement. You can be there. I'll tell you what it is, then maybe I'll do it. So it depends how it's couched and the full picture of it. But if it's just a typical boilerplate, well, we need a statement, then no. And I think those are usually asked for, not really in good faith. So let me know what your thoughts are. Hit me back in the chat comments here, the Q&A. All right, Eli, how can you get a settlement above the policy? How can you get a settlement which includes the defendant contributing? Here's how it basically works, Eli. Let's say you get sued for an automobile accident and you have a $100,000 policy. And the person's damages, are worth more than $100,000. They got really badly injured. And they say, listen, we're not going to accept the policy. You could say, all right, I'm not that flush. I'm in debt. I've got this or that, but I'll contribute. Then you work it out. You form an agreement with the plaintiff's counsel to accept the 100,000 policy plus another 25 from you out of pocket. You do a stipulation of settlement. I did this recently. I had a death case in Long Island. It was a 100 policy, struck and killed a retired woman in her late 60s. And we did some homework, and it turns out that it was a young couple that owned the car, and they were both in tech. One worked for Meta. And I said to the carrier, look, they're underinsured. They've got money. We're going after them unless they agree to pay out of pocket. And if they don't want to, and they're going to cry poverty, I want to see tax returns. We see they live in a very nice neighborhood. They have a nice home. There's no way. And so I negotiated. Next thing I know, I heard from their personal lawyer, and we got them to pay several $100,000 out of pocket in addition to the coverage. And we agreed and we settled the case because they didn't want to go to trial and get a judgment against them. Judgments are not an easy thing for people that have assets. It's just not. So that's how you do it. Hopefully that makes sense. All right, Russell, revised. What sources do I know of to find out about a potential defendant's insurance coverage, especially pre-suit? Same answer. It's very hard pre-suit. The first thing is you send claim letters. You tell them to turn it over to their insurance company. You can ask them. There's sometimes where you can contact until they're represented by counsel. Just call them right up. Hey, did you have homeowners insurance? Do you have liability insurance? If you do, can you give me the information? I'll reach out to the claims company for you. So sometimes reaching out to the tortfeasor directly is the way to go if you don't have anybody else to contact. Susan, can you give bullets of special issues when victim is on Medicare in a no-fault state? So I'm not sure the full question, but let's assume you've got a case where someone's injured and Medicare paid for their treatment. Yeah, that's going to be a lien. So the amount that Medicare is paid is a value of damages. So if you're trying to figure out a value to settle the case and your 68-year-old client was hospitalized for a month and Medicare paid for the bill and Medicare paid $800,000, you're going to exchange that with the other side and say, we need enough to compensate my client to help pay off the Medicare lien, which they're statutorily entitled to pay fees. So that's how you deal with that. You get the lien amounts and that becomes a part of the damages. Linda, hi, plaintiff's counsel here, and I see I've got a couple minutes left. Pretty much 100% of the time, defendants give blank objections to all discovery demands. How is it possible to deal with this? Motion practice. All right, Linda, I'm going to keep moving on because we're talking pre-suit. The bottom line is that if you're stuck in motion practice because defense counsel is being difficult, you try and go around defense counsel, go above their head in their firm, go straight to the adjuster, claims rep if you can. Otherwise, you just got to fight them in court. That's why we litigate. It's a backstop if we have to. Same with umbrella policies, Eli. Again, it's up to defense counsel to tell you what the additional policies are. You got to try and find out. You got to keep asking questions. Put it all in writing. All right. Let's go. Let's see. We can client's insurance. Nazreen's is asking for client to sign an authorization to extract vehicle data records. Do we object? No, I have no problem with event data recorders. That's what ED are. As long as it goes both ways. I'll agree to let them pull the event data from my client's car as long as they give us the event data from their car and provide us with what they pull from our car. It's fine. The event data recorders give lots of information. Again, as long as you have a good rapport, that helps. It helps get cases resolved. You look at the data, you talk about it with your adversary, and you go from there. Alan, before going to mediation, is it important to get an offer? Why or why not? No, I don't think so. If they're agreeing to go to mediation, they agree to go. You try and premise it that it's in good faith, but sometimes you show up and they don't offer anything, and you're like, this is a waste of time. So again, that goes to rapport. It goes to get a sense of where you're at. So I think that in cases that you have a really strong feeling, it may just be an absolute waste of time. You could say, I need you to put something on the case in good faith and ask them to do that. If they won't at all, then maybe you agree not to mediate. All right. Reed, I do plaintiff's work. Defendant policyholder died. Litigation judge wants us to set up an estate for the policyholder. Son of policyholder stated policyholder does not have assets. Is a public administrator needed? Maybe. This is a pain in the ass situation, Reed. I'm sorry. I would speak with a surrogate court specialist. Email me off this and I can put you in touch with someone to get the answer to that. And yeah, I have dealt with it a while ago and it's a pain, but I think you generally need to get somebody appointed. It's usually, I think, the public administrator that does it. Okay, Jay, what do you advise doing if your client refuses to have surgery, yet the doctor says in their records they should have it? Look, if a client's not going to have surgery and they tell you come hell or high water, I'm not doing it, then they're not doing it. And you've got to assess the case based on that. You can argue the doctors are, to your adversary, look, here it is in the record. She needs surgery. He needs surgery. And they'll probably say, fine. When they do it, let me know. I'm not going to pay, nor should they really. Look, I try and make that argument too on the plaintiff side. Look, they need surgery. Do you want to wait now? Now, again, this could be an opportunity where they can say if it's soft tissue and everywhere they're being told they need a fusion, but your client's saying there's no way I'm going to do it. I would suggest to the carrier, listen, if you can settle the case for under 6 figures now, instead of just offering $2,500 because it's potential they may get fusion, you're going to pay a lot more, do it. So you may want to finesse that little gap right there and try and argue they're going to need it. Why don't we just settle the case now and I'll give you a discount and bluff as best as you can. But if ultimately they're not, then you have to address that and deal with that and just deal with what you're dealing with. But, you can't tell a client, push them to have surgery, never do that. But, let them know clearly that their case isn't going to be worth probably more than a couple $1,000s if they don't have surgery, because their case will get dismissed under threshold. If they have surgery, they may get 7 figures. But obviously, whatever they want to do, as long as they're clear to you and you're clear to them, then you'll proceed accordingly. All right, there we go. I think it's a wrap. Great to see everybody.